Hello, this is Radio Law on YouTube. This is Dr. John Olson. Radio Law is my audio blog about legal matters, anything to do with the law, anywhere in the world. So today I'm going to talk about the confirmation hearings in the US Senate for Judge Brett Kavanaugh. Many of you may wonder what business this is of a British person. Well, forget that, okay? Let's forget international boundaries. Anything that happens in the law almost anywhere in the world concerns all of us, and particularly what happens in the United States. Any aspect of US government is important to people right across the world. So hopefully we've got that out of the way. Now, Judge Kavanaugh. Does the fact that he is a nominee of President Trump mean that he will do the president's bidding? This has given a number of people a lot of anxiety. And in fact, anybody who was watching the confirmation hearings in the Senate will realize that there was a degree of hysteria. There's no other way of expressing it on this question. I'm referring to senators such as Cory Booker, who was allowing himself to believe, or at least to appear to believe, that Judge Kavanaugh was a dangerous man who would rewrite Supreme Court jurisprudence. Personally, I think that the president has actually scored an own goal. Why do I say this? Because I think that Judge Kavanaugh, if he is confirmed, will not succumb to President Trump's wishes. He will do what he thinks is the law. And this is because I think that Kavanaugh is his own person. But let's get specific. Why are people opposing Judge Kavanaugh? What are they saying about him? Well, there are three things, basically. First, people seem to be of the opinion that he favors this idea of executive immunity. In other words, the president can do what he likes and the courts can't stop him. This is complete nonsense. First of all, it is totally against Republican principles anyway. The president must not ever be allowed to become king. So that is a fundamental principle of Republicanism, and I don't just mean Republicanism with a capital R, but generally anybody of a conservative bent in the United States would take that view. Second, there is the fear that he might overturn Roe v. Wade, the landmark case on abortion rights. So that's the second concern. And then the third concern is that the very fact of Judge Kavanaugh becoming a justice of the US Supreme Court would swing the court, quote, to the right, unquote. So let's deal with executive immunity. Nowhere has Judge Kavanaugh stated that presidents should have immunity. What he has said is that in the landmark case of United States v. Nixon, if you remember, that's from the Watergate era, this may have been wrongly decided because it could limit the power of the president to control information in the executive branch. And he said that he had not believed this until 9/11. So it was 9/11 that turned him to this view. Now, he never implied or stated that the Nixon case was wrongly decided as to the basic point that a president is not above the law. He never said that. He never said that the president is above the law, and people should stop pretending that he did. And he has nowhere indicated that a president is above the law. So on the question of whether a president can be indicted in a criminal action, firstly, it is the long-standing policy of the US Justice Department that a sitting president cannot be indicted on a criminal matter while in office. Second, Judge Kavanaugh does not favor presidential immunity from civil or criminal suit. He merely said that any such actions should be deferred until the president's term is finished. This is because he considers that a president should not be burdened with such cares while in office. How can you possibly run a country if you have to worry about a court case? That is essentially, I think, what Judge Kavanaugh's argument is. And also, imagine how many people have got some kind of beef against the president, any president. Presidents would be in court every day if they had to deal with this type of issue. So cast your mind back to the Watergate era and the Supreme Court case that arose out of that, United States v. Nixon, which has been talking about it. In United States v. Nixon, the president opposed a subpoena which ordered him to release tapes made in the Oval Office. The Supreme Court ruled against the president, even though 4 of those on the bench were Nixon appointees. And in fact, it was a unanimous decision of the Supreme Court. So that should show you how the Supreme Court works. People do not necessarily go according to party lines. There is no aisle in the United States Supreme Court. There are no caucuses. Judge Kavanaugh has said that, and I really believe that to be true. So that case, US v. Nixon, was about a subpoena. Whether a court can order a president to obey a subpoena. Judge Kavanaugh considers this to be one of the great moments in judicial history. It shows, he said, probably more than any other case in the last 200 years, the independence of the judiciary. Note that that case was not about whether a sitting president can be sued. It was about whether any person including the president, would have to obey a court subpoena. And in that particular case, it was a court subpoena from a district court. A lowly district court decided that the president should obey the subpoena, and the case went all the way up to the Supreme Court, because of course Nixon appealed. So Judge Kavanaugh has merely said that forcing a president to disclose documents took away the power of the president to control information, and he considered in the post-9/11 climate that that was very important. That was what concerned him. He said to the Senate that the Senate could pass a law that the president was not above being sued if they wanted to pass that law, or they could pass a law to the effect that he was not above the law. Of course, the Senate did no such thing, and I think the proper course of action is that which is currently being taken, namely the appointment of an independent counsel. We already have that independent counsel in Robert Mueller, but that counsel should be appointed, in my opinion, by a joint committee of Congress, not by the president, or perhaps a totally independent commission. Now, it's true that in US v. Nixon, the court considered the question as to whether the president is above the law. Of course they did. They concurred with Justice Marshall, who in the case of United States v. Burr, that's B-U-R-R, that a president is not above the law. They concluded that. But the court in US v. Nixon didn't hand the special prosecutor a blank check. They didn't say you can have access to everything on those tapes and publish everything. On the contrary, the special prosecutor could only make public, in any case against the president, those materials which were directly relevant to a specific allegation of criminality. Judge Kavanaugh has said that the United States v. Nixon case is precedent, and that's obvious. So in other words, he, as a judge, would be bound to follow that ruling unless a majority of the judges on the Supreme Court found legal reasons not to do so. What is also not always understood is the United States v. Nixon was decided on its facts. The special prosecutor was not engaged in a fishing expedition. He had already got good reason to believe certain things about the president's actions, in great detail, and that was largely due, of course, as we know, to John Dean. So the facts of the Watergate burglary were well known to the special prosecutor, not just from newspapers, but first-hand from John Dean. Now, one of the senators here in this hearing of Judge Kavanaugh's confirmation asked him the hypothetical question as to whether he would overrule United States v. Nixon if he had the opportunity. This is a totally naive question. You cannot ask a sitting judge such a question. He or she would have to decide each case on its facts. And while it's true that in certain circumstances the facts might lead a judge to rule against United States v. Nixon, it is definitely not something that a judge could comment on, a sitting judge. In fact, it's a very more than naive question, because judges cannot compromise their independence by opining on matters related to an issue that might come before them in the future. Now, several pundits have made out this shows that Judge Kavanaugh is ambivalent on this question. This is just political point scoring and shows how some senators need to respect the law a little bit more. Now, this is really ironic because most, if not all, of the members of the Judiciary Committee of the United States Senate, they are lawyers, but some of them just pretend to be ignorant about basic legal principles. Of course, a judge is not going to speculate hypothetically. It's a completely nonsense notion. Now, a second concern among those opposing Judge Kavanaugh's confirmation related to this question of abortions. As is well known, the case of Roe v. Wade, it was decided 40 or 50 years ago, whatever. Judge Kavanaugh must, as many other judges, support the finding unless the Supreme Court reverses it. So the controversy over what Judge Kavanaugh thinks about Roe v. Wade arises because he's written that he's not convinced that, quote, all legal scholars consider that Roe v. Wade is settled law. This was in response to a claim in an email. He wasn't talking constitutionally here. He was simply discussing this with somebody in an email. And the claim in that email was that, quote, it was widely agreed among legal scholars that Roe v. Wade is settled law. What Judge Kavanaugh was disputing was that it was widely accepted among legal scholars. He was not saying it was not settled law. He was not giving an opinion on that point. He would not give an opinion on that point for obvious reasons. Again, members of the Senate, certain of them, chose to misinterpret this point. So what many of them don't appreciate or choose to ignore is that judges have to be so careful about expressing an opinion regarding a case when they are not sitting on the bench, in other words, in a public forum like the Senate. This is because almost any opinion could compromise the judge's independence if a similar matter were to come before their court. Moreover, when a judge declines to give an opinion on a hypothetical question, these are not mere empty words. The question is called hypothetical simply because until the judge hears the case, he or she will not know what the particular facts are on which the case might turn. I'm stunned that members of the Senate, that august body, that great institution, should pretend not to understand this point. It is fatuous and ridiculous. So this was why when they asked Judge Kavanaugh if he would overturn Roe v. Wade, he made 2 points. First, he would just be one among 9 judges. He could not, by definition, overturn anything on his own. He described himself as a team player. Second, he could not give an opinion on a hypothetical case. He implied, but did not need to say, that a judge will always decide a case on the facts before the court. If the judges of the Supreme Court nominee were to give an opinion on this point, he would be compromising his independence. Senators who ask such questions are making political points in order to extract a judicial opinion. It is an absurd idea. So now, let's deal with the question of whether Judge Kavanaugh, if he was going to be confirmed as a Supreme Court justice, whether he would, quote, swing the court to the right, unquote. In his 12 years on the DC Circuit Court, he has heard approximately 2,000 cases. And there are 11 judges on the DC Circuit Court. 4 of them Republican appointees and 7 were Democratic appointees. He agreed with the majority in over 90% of cases. So this demonstrates that he does not necessarily uphold a party line. He himself has said there is no political divide in the courts of America, especially not in the Supreme Court. Recall that he's opposed the executive on more than 20 cases, even when President George W. Bush, who nominated him for the DC Circuit Court, was still in power. Bush was his old boss at the White House, but Judge Kavanaugh did not hesitate to oppose the executive whenever the law showed him that that was the right thing to do. A judge who is partisan will very rapidly reveal him or herself to be so and will lose all credibility. So based on what I have seen and read about Judge Kavanaugh, I do not believe he is a partisan judge. Would he want to go down in history as a biased or partisan judge? I think not. So those opposing Judge Kavanaugh's confirmation should perhaps just step back and look at some first principles. Firstly, Judge Kavanaugh could not risk being partisan even if he wanted to be. Second, his record as a judge is impeccable. The Supreme Court has upheld him on at least 13 occasions, and they have often quoted him in other cases. And more often than not, he has agreed with judges who come from a different political background from him. Thirdly, he has the intellectual capacity, to say the least, and the grasp to understand any case that comes before him. Fourth, he may be of a conservative turn of mind. That is true, but he should not be thought of as a staunch Republican or a GOP member. He is neither. Now, referring for a moment to the Second Amendment, let's just go back on that for a moment. In his decision on the Second Amendment, he's simply been upholding the words of the Constitution. I believe that what needs to be changed is possibly even an amendment to the Second Amendment to define it more closely for modern living. I think the Second Amendment really does not support a textualist and an originalist interpretation, or alternatively that the court in Heller defined individual gun rights just far too narrowly. So the court really needs to look at the circumstances under which people have the freedom to bear arms and which arms they have the freedom to bear. I also just want to say something about Judge Kavanaugh's rulings on pollution. Now, the real problem, I believe, is not with Judge Kavanaugh. It is that Congress has passed a law which is flawed because of its vague directions granting the EPA the power to make regulations. So the real problem is the legislation is not fit for purpose. It's not that Judge Kavanaugh is in favor of polluting the environment. That is an absurd idea. The real problem is poor legislation by Congress and the structure of arm's-length government by quasi-independent agencies. And that's a phenomenon that's occurring in all Western countries, this idea that government is being delivered by these arm's-length agencies. So if Congress delivered its constitutional mandate more and made better laws with more careful drafting, especially on such areas as climate change, there would be less of a political burden on federal courts and the Supreme Court. But we all know that there's far too much lobbying in the Senate, and very often the lobbyists will actually write the legislation and they just pass it on to somebody who they have contributed to their election campaign. So that this is a dastardly setup. And I think there's a kind of impudence about certain senators criticizing Judge Kavanaugh, given their own record regarding the accepting of election payments. So for all the reasons that I have mentioned here, I'm quite confident in this judge. I predict that President Trump will, on the whole, be very disappointed in him if he's confirmed to the Supreme Court, because if he becomes a Supreme Court Associate Justice, he will not be following President Trump's publicly declared wishes. He will decide each case on the law and on the facts. And thank you very much for listening, and I hope that you enjoy the topics that we discussed. Goodbye.